Rick Wilson, Neetampa, good day, friends. Neesu, Wushuwunoag, Federation of Aboriginal Nations of America. Hope that this day finds you well. It's a bit rainy up here. Heard that it's been very rainy down in other parts of the quote-unquote U.S. We know there's been terrible happenings down in the southern region. So just praying and asking Creator for blessings upon all those who are going through struggling times right now. And just feel honored to be able to be discussing with you today. As usual, I'm just back with some of my ramblings. I thought it was appropriate today, particularly given some of the happenings going on in Indian country last week with the particular ruling against the Mashpee tribe, taking their lands out of trust and all of that good stuff. So a lot of conversation going on around it. And I think that a lot of it is based in the misunderstanding of the colonial system and how it's got a grasp on Aboriginal people here, indigenous folks that are Aboriginal to this land, so that people can understand how and why the system is moving the way that it is, and why ultimately FANA has chosen to conduct itself or build its relationships and its foundations amongst its member nation in a way other than what has been most widely adopted by Indian tribes, which would be the federal recognition relationship and process. So in order to understand how a situation like Mashpee happens, and why we're probably going to see a lot more of that, especially under an administration like Trump's, and also to understand why you also see at the same time other tribes getting federally recognized. Because remember, the Trump administration recognized some tribes in Virginia a few months ago. So to understand how that works out, you have to first go back to the Indian Reorganization Act. And this was passed on June 18th, 1934. It's also known as the Wheeler-Howard Act. This was also considered as the Indian New Deal. And the real goal was to reverse traditional goals of assimilation of Indians into American society, and to strengthen, encourage, and perpetuate the tribes and their historic traditions and cultures. Now think about that, right? The same country that spent hundreds of years destroying and attacking and forcing Indian nations to sign treaties, now all of a sudden wants to stop promoting their culture, their traditions, promoting them being Indians again. So this is all under the Indian Reorganization Act. It restored to Indians the management of their assets, land and mineral rights, the management, included provisions intended to create a sound economic foundation for the inhabitants of Indian reservations. And it goes on some more. You can just Google this stuff, right? But there's something, I want to go back first because we're talking about assimilation, but I also want to point out something. And you can just pick up the Wikipedia and you're going to see this interesting point right here. So it says, the Indian Reorganization Act of June 18, 1934, or the Wheeler-Howard Act, was U.S. federal legislation that dealt with the status of Native Americans known in law as American Indians. Native Americans known in law as American Indians. So that tells you right there that Native American is not the lawful proper classification and title of American Indians. Keep that in mind. So now the Indian Reorganization Act is meant to stop the long-held tradition in the U.S. of assimilating Indians. So if we look at cultural assimilation of Native Americans, look at the language again. It says the cultural assimilation of Native Americans was an assimilation effort by the United States to transform Native American culture to European American culture between the years of 1790 and 1920. George Washington and Henry Knox were first to propose, and in American context, the cultural transformation of Native Americans. They formulated a policy to encourage the civilizing process. With increased waves of immigration from Europe, there was growing public support for education to encourage a standard set of cultural values and practices to be held in common by the majority of citizens. Education was viewed as the primary method in the acculturation process for minorities. So once again, you can look for more details, but I want to pull some things out of here. It's going on from 1790, they say to 1920. I'm going to say to 1924, all right? but 1790 to the early 1920s. And it also picks up steam as more European immigrants come to the lands. So think about this for a moment. You have European immigrants coming here willfully. And then on the other hand, you have the Native Americans who have been here who aren't for all of the waves of immigration. And you have the U.S. in the middle encouraging the European immigration, but trying to assimilate at the same time the American Indians. And it goes on to the early 1900s. Now, why would the U.S. keep up this process of assimilation until the 1920s? Why would they do that? And this is going to bring us back to an earlier discussion I did on the Snyder Act, the Indian Citizenship Act of 1924. And this basically said that any Indians born within the territorial limits of the United States are considered U.S. citizens. So we have assimilation going on until an act passes that says that all Indians born within the territorial limits of the U.S. are citizens in 1924. And then 10 years later, in 1934, we get the Indian Reorganization Act, where now they want the Indians to assume and promote and uplift their culture. Why? Well, because with the Indian Citizenship Act, the term U.S. jurisdiction, from our understanding, really boils down to being issued a U.S. birth certificate. So if you're an Indian who has a state birth certificate that gives you U.S. citizenship, you're considered a U.S. citizen. You're born within the territorial limits. So once you start having Indians either forced into citizenship or given citizenship through birth certificates, Social Security, whatever it is, however they're becoming citizens, they're now under the jurisdiction of the U.S. So the U.S. doesn't have to deal with them as separate sovereign nations anymore. They don't have to. They don't have to deal with them as separate sovereign nations. They're citizens. At best, they're going to be domestic dependent nations, but they're not going to be sovereign. They're going to be under the jurisdiction, under the protection of the United States as inferior nations. So once you have this Indian Citizenship Act, the Indians are now citizens. It's now okay from a jurisdictional standpoint to let the Indians be Indians again, because remember, Native American, the lawful term of a lot of the individuals classified as Native Americans is American Indians or Indians. So now they're Native Americans under the jurisdiction. So you don't need to worry about treaties. You don't need to worry about human rights. You don't need to worry about any of that. These are all the U.S.'s citizens with the Indian Reorganization Act. And this took place, like I said, in 1934, right? So that's just a little bit of context. The Snyder Act, they're forcing Indians to assimilate. They want them to do away with every bit of the savage that's in them until the early 1920s when the Indian Citizenship Act passes. Now all of these Indians are all of a sudden considered U.S. citizens. 10 years later in 34, it's now okay for these Indians to go back to being Indians because they're not Indians anymore. They're Native Americans. By law, they're Indians, but remember, they're subject under jurisdiction now, so their classification is now a Native American. So we followed so far, right? You got assimilation, Indian Citizenship Act, Indian Reorganization Act. And the Indian Citizenship Act is the Snyder Act. The Indian Reorganization Act is the Wheeler-Howard Act. So now you have 34, you have all of these tribes or whatever. After that, BIA gets established, federal recognition process rolls out, all of that. Now we're going to jump forward to a case in 2009, Carcieri versus Salazar, 55 U.S. 379. This was in 2009. And this is going to be key because this case is going to point back to the Indian Reorganization Act of 1934. And I'm just going to give the generals. You can do more research on it, but I'm just going to give the generals in particular because this involved my people, the Narragansett Indian tribe. Those are my cousins down in South County. All right. So this hits near and dear, and I've really gotten a chance to get some understanding of it, particularly for myself. And then in sharing that information with the other reps from FANA, agreed that the perception on it was correct and true. And it actually, well, let me not get to that first, but let's talk to Carcieri versus Salazar. It was a case in which the Supreme Court of the United States held that the federal government listen to this, could not take land into trust that was acquired by the Narragansett tribe, which did not have federal recognition until 1983. While well documented in history records and surviving as a community, the tribe was largely dispossessed of its lands while under guardianship by the state of Rhode Island and before suing in the 20th century. Now, this goes back to the 1881 detribalization of the Narragansett tribe by the state of Rhode Island, which was unlawful. States can't detribalize anyone. Even if you agree with the notion that the U.S. can detribalize a tribe, which we most certainly don't agree with, the states most certainly didn't have any lawful right. Going back to the Constitution, all relationships with the Indian tribes were designated to the Congress. So it basically says that while the Narragansett was supposedly under guardianship of the state of Rhode Island, they were dispossessed of their lands, but it's not mentioning that the dispossession was illegal, which is why the state was able to sue in 81 and win. And then they got federally recognized after that. Now think about this. Indian Reorganization Act in 34. Now you got all of these tribes being federally recognized, BIA putting lands into trust for them. The Carcieri versus Salazar, for some even more background, came out of the Narragansett smoke shop raid. This took place, oh goodness, give me a second. Let me get the exact date right. One second. This took place in 2003. The Narragansetts, claiming to be a sovereign nation, decided to put a smoke shop up and sell tax-free tobacco on one of the state roads. Really ugly situation. Governor Donald Carcieri at the time sent in the state troopers. A lot of abuse. People got tackled, slammed. I think someone got their arm broken. It looked awful. Absolutely awful. But then the Narragansetts went to court behind it and lost. And why did they go to court behind it? Well, because after they got their case in 81, I believe, or 83, 81, I think, they then agreed to a federal recognition relationship. And that pretty much allowed the federal governments to then have jurisdiction over them and put the Narragansett lands into a federal trust. They were then given a reservation and also placed under a Public Law 280 relationship, which is a video I'll do on that topic at some other time. But basically pretty much put themselves under the full jurisdiction of the state. So they didn't have any lawful right to go as federally recognized Native Americans and sell tax-free tobacco on a state road. They didn't have the right to do that because they traded their sovereignty away when they got federally recognized. So the smoke shop raid happens, very violent, and they take it to court. And this was the outcome, Carcieri versus Salazar. They say that not only was the state right in what it did, this is what the law says, but further that the Narragansetts didn't have any trust lands because the BIA, who the federal government appointed, didn't have any lawful authority to take any lands into trust. That was designated to Congress, and it had to be done by act. The court ruled that the phrase of tribes now under federal jurisdiction in the 1934 Indian Reorganization Act only applied to those tribes that were federally recognized when the act was passed. And it ruled that the federal government could not take land into trust for the Narragansetts or other tribes that were federally recognized and acquired land after 1934. So peep how they still got the Indians, right? Not only do they first try to assimilate us, then dupe us Indians into citizenship, they then passed the Indian Reorganization Act, put particular language in there, and then go through a process that's unlawful and illegal after that with all of the tribes. And we refuse to believe at FANA that they weren't aware of this. Of course they were aware of this. It was just, how do you set it up so that in the future it can come back to bite the people that think that you're trying to do something good for them? So with this situation, it pretty much cements in law that any Indian tribe that got federally recognized after 1934 and had the federal government put lands into trust for them, they don't have any trust lands. They don't have any trust lands by the Carcieri versus Salazar ruling. They don't have any trust lands, but they're still federally recognized. Notice it doesn't say that they can't be federally recognized. So it doesn't mean that they can't be put under U.S. jurisdiction. It just means that they can't have any lands put into trust for them. So you can be subjects, but you're just not going to have your lands. So that's where we're at right now. And that's why we saw the ruling with the Mashpee tribe. Now, we can get into other particulars about the history and the claims that were made. I'll leave that up to the particular tribes that deal in that area. That's not something that FANA itself is going to get involved in. But we do support the Poconokeets and their stance on it as the Poconokeets are FANA member nations, and their stance is clear and lawful. So we're not going to get into that. But if you're wondering how they get lands taken out of rule, because they agreed to a federal recognition relationship, which made them subjects, which now makes all of their possessions, under the jurisdiction of the U.S. like any citizen would be. So, yes, the U.S. can take lands out of trust if they so choose. They're the trustees, they're the guardians. And if they feel that it's not correct, or if there was a violation of the law, then they have every right to do that. So when they say that phrase right there, now under federal jurisdiction, means you had to be under federal jurisdiction at that time, and the Indian tribes went and signed on and agreed to all of this and didn't rebut it, well, then the feds have every right under law to do what they're doing. So when you look at what's going on with Mashpee and all of the other tribes, it's because of the way that the law was written and the way it can be applied. And if you did not have lands into trust, then the only way you can do it is by act of Congress. Now, what happened earlier this year with the Virginia tribes? It was the Thomasina Jones or something like that. I forget the name of it. But it was an act that was passed and accepted and signed by Trump. So why would Trump be, at the same time that he's taking lands out for the Mashpees or under federal recognition, be agreeing to recognize other tribes? Think about it. Why would he at the same time agree to recognize tribes, but then also be taking lands of trust from other tribes? Because if you agree to a federal recognition relationship, you're under the jurisdiction. There goes your sovereignty. And if you're under the jurisdiction, then what right do you have to complain when the feds decide to do something with their trust lands? Your lands are in a federal trust. Your lands are in their trust. You allowed or agreed to have your lands put into their trust as an Indian nation, and now you're Native Americans. Now you're Native Americans. So we're probably going to see more of this going on as things unfold. As Trump being Trump and the administration being the administration. And one of the things we've noticed is that they're very astute in how to navigate the law. They're very astute in where the holes in the law are that they can exploit. So we're probably going to see more of this going on with Indian tribes who agreed to a federal recognition relationship and then had their lands put into a federal trust, because those are two separate things. Recognition and the process of putting the lands into a federal trust are two separate things, although they go hand in hand. So we're probably going to see this a lot more with more tribes who have agreed to be federally recognized and had their lands put into a federal trust. You'll probably be seeing the federal government move to take more of them lands out of federal trust. So now, always, whenever we present the problem, we always like to present the solution as we understand it, right? So let's look at this. The U.S. Supreme Court has ruled and agreed that no lands after 1934 and the Indian Reorganization Act were lawfully put into federal trust unless they were done by act. Well, that of course means that all of the Indian tribes out here who have claims to ancestral lands can then have the opportunity to put the lands into trust themselves. Because if the feds haven't done it, if they ruled that since 1934, unless it was by act of Congress, no lands were put into trust, right? Then the door is wide open for the tribe to put them into trust. And one of the things that we need to understand, and one of the things that really holds us back from being truly sovereign nations, is that we consistently look as if we need the federal government to do things for us, when in actuality, we can do everything that the federal government can do for ourselves. We just have to know how to navigate the system correctly. So when you hear FANA saying that nations need to A, document who they are to pre-colonial times, and then B, be looking towards the creation of a tribal trust, Carcieri versus Salazar is lawful substantiation of everything we're saying. There are no lands for most of these lands in trust by law. The Narragansetts don't have federal trust lands by law. Per the Carcieri versus Salazar ruling, they're just federally recognized. We just saw what happened with the Mashpees. And like I said, you're probably going to see more of this is going on. But if you are a tribe that has been unrecognized, not signed any relationship with the federal government, not putting yourself under any of their jurisdiction, then you are in a tremendous place to truly act like a sovereign nation, take the steps you need to take, and take the lands into trust yourself. As a nation, not as an individual. Now, this has to be a nation thing because you need to be able to deal nation to nation with the U.S. Because they're going to come and try to challenge your claims and want to know what right you have and this, that, and the other. And you need to be able to substantiate. You can't point to someone that has no relationship to you and say, well, they got and they did, so we... No. Who are you and what are your claims? And they know. They know who you are. We keep saying you don't know who you are. So in the end, from FANA's perspective, for our federally recognized brother and sister nations, this is a horrible, horrible ruling in Carcieri versus Salazar. But if you are one of those individuals who, by Creator's divine wisdom, did not allow you to ever be federally recognized, and we know that some of our people went for it, had all of the history and everything there, and the feds were just saying no, right? Just no. 10, 15-year process, no, not going to federally recognize you. For those tribes and nations that have been treated like that, this is the greatness of the Creator that we serve above, right? Because what seems like madness and craziness to us, in the end, ends up being exactly what we needed. Because if we did, any of us did get that federal recognition, there goes any of our claims, we signed them over to the U.S. But if you didn't, you're in a perfect position to start looking at true sovereignty, which begins with the establishment of yourself properly as a nation, and then the public notice that you are now in a position not to be wards of the U.S. anymore, not to be considered mentally incapable of taking care of your own lands, but that you're in the capacity to do it yourself. So, the Indian Reorganization Act was the follow-up to the Indian Citizenship Act, which has now had the hammer brought down on it by the Carcieri versus Salazar Act, all with the intent of duping sovereign nations into signing their sovereignty over to the U.S. and then taking their lands from them still. Just making them straight U.S. subject citizens in about 09, what's that? 24, 15, so 85 years, within an 85-year process from the Indian Citizenship Act to the Carcieri versus Salazar, make all of these Indian citizens and then just take away their lands after they sign them over. 85 years to do that. Colonization is still alive and well, but the beauty of it is that Creator has shown us a different path. So you can deal with the feds believing that they have your interest in mind if you want, Indian nations. You can pursue the federal recognition relationship if you want. You can do all of that. Do it. As a nation, you are well within your rights to choose to do whatever you want. But we just want to show you what the real game is that they're playing on you and what you're getting yourself into when you agree to that, or when you agree to let Congress pass an act to put your lands into their federal trust. If you're going to be sovereign, then you shouldn't be looking for the feds or any other nation to do anything for you. You should be looking to figure out how you do things on your own. And if sovereignty is truly the goal of our nations, then we need to start to think and act sovereignly. And if we don't, then what right do we have to complain when the federal government or the Trump administration decides to do what this U.S. has been doing since it was formalized here in Indian lands? Why would we? Who are we kidding? After hundreds of years, we're still falling for the same tricks. We don't have to. You don't have to anymore. There's different paths. There's different ways. If you're willing to entertain the notion that your understanding is incorrect. And this is what the FANA member nations have done. Each of the FANA member nations have gone through the process of forming their constitution, their tribal government through their councils, and taking their own lands into trust. Because what other way would you go about doing it if you're talking about being sovereign and on a nation-to-nation level with the U.S.? How can you be on nation-to-nation when the U.S. is doing things for you? So just wanted to share that, family. Please do some more background on this. Did the last video on the Snyder Act, Indian Citizenship Act, talking about the Indian Reorganization Act, which was the follow-up to Assimilation, which then ultimately culminated in the Carcieri versus Salazar ruling of 2009. And that's why you're starting to see a lot of what you're seeing going on, particularly with Mashpee. And like we said, you'll probably be seeing more going on. But there is hope. Carcieri versus Salazar means that they've admitted that they didn't take any of the lands after 1934 into trust properly if they did it through BIA, which means that you still have the opportunity to do just that if your tribe is who they actually say they are. So, looking forward to seeing the comments in the section down below. Please do share because there's still more information about these things. It's always encouraging to see people adding more information to the little bits of information that we share here. And we just thank you all for your continued support, paying attention and awareness, and for just continuing to educate yourselves. And for most of all, and most importantly, finding out who you are and honoring your ancestors, honoring our Creator, honoring all of those who are out here fighting this good fight against colonialism and the system that it's enforcing upon us. As always, katapatush wuchia chusuta nitampag. Thank you for listening to me, friends. Kapish Kanash. And I look forward to connecting with you all soon. Aho.